Everybody, and thank you, Alejandro and Ima, for joining us today. So our first question is, or series of questions is going to be for Alejandro in understanding the user's perspective. So what is the historical context of disability rights in Europe pre-EAA? And what was your European Disability Forum role in getting the EAA enacted?
Thank you very much, Matthew, and many thanks for the invitation. Let me start by introducing a little bit the European Disability Forum, EDF, the organization for which I work. EDF is the non-governmental and non-profit organization at European level, bringing together the European disability movement. So basically, those organizations that work representing the different disability groups, such as the European Blind Union, the European Union of the Deaf, Autism Europe, Inclusion Europe, representing people with intellectual disabilities, and also those organizations at national level representing the disability community in their country. So EDF is an organization led by persons with disabilities and their family. And our main mission basically is to defend, promote, and advocate for the rights of persons with disabilities, 100 million in Europe. Our mission is therefore to advocate for the full implementation of the UN Convention on the Rights of Persons with Disabilities, which, as you all know, accessibility is one of the principles, of the preconditions to enjoy all of the rights enshrined in this convention. And we do so by involving persons with disabilities in the policy making, particularly in the policy work of the European Union. Not only that, but that's, let's say, our core activity, and also to help them, to help our members, over 110 member organizations, to really build their capacity around European policies and how they can utilize them at national level to advance on the rights of persons with disabilities. My role in EDF as a Deputy Director of Health Policy is to coordinate this advocacy work that I just explained, but in the past I was taking care of accessibility policies, mostly digital accessibility policies. So going a little bit back in history, EDF was founded in 1996, thanks to a project funded by the European Union. And since the Amsterdam Treaty of the EU recognized the persons with disabilities, the European Union has been increasingly present in the everyday life of persons with disabilities, with first initiative concerning accessibility in certain modes of transport, the European parking card, for example. These were some of the very early initiatives on disability rights taken and adopted by the European Union. And since then, obviously, EDF has been very active at international level in the preparation and drafting of the UN Convention, in advocating for the EU as a supranational organization to ratify this convention, which they finally did in 2011, and all member states, along with our members, and focusing on accessibility, obviously, and one of the core policy areas that our constituency is obviously very active on, and in which the EU can really and has taken a step forward since for example, 2005, when we started developing the famous EN 301549 that we will talk about today as well. EDF also advocated and gathered 1,003,000 signatures for the EU to adopt an anti-discrimination legislation that included accessibility back in those days. But since then, unfortunately, the Council of the EU, and this is the institution that represents member states, they've been blocking this piece of legislation again since 2008. And recently, unfortunately, the Commission has announced the intention to withdraw this proposal. Very unfortunately, not good times, as you all know, for diversity, equality, and inclusion inclusion policies. Back in 2009, since we saw that this legislation could take time, we never thought it could take that long or it could never be adopted. EDF launched a campaign, Access Denied, calling for specific accessibility legislation. And first, for example, we got the Web Accessibility Directive. The proposal was launched in 2012, and this only covered the public sector, websites and mobile applications. In the end, was adopted in 2016, and in 2015, the Commission finally launched the proposal for the European Accessibility Act, which, as the Web Accessibility Directive, instead of using non-discrimination as a legal basis, they use one of the strongest competences of the European Union, which is its internal market. So with this legislation, obviously EDF as an advocacy organization, as the lobbying of persons with disabilities, we followed the legislative procedure. We answered all the public consultations. We met with the high-level politicians and at technical level to make sure that this legislation was being proposed. It took some time for the Commission to decide to finally propose it, but once they launched the proposal in 2015, we prepared proposals for amendments. We informed our members, the general public. We even demonstrated in front of the European Parliament, because the member of the European Parliament leading on this file was not very keen in meeting with the disability community. So it was a difficult process in which there were many, let's say, difficulties concerning and really hot topics concerning, for example, the accessibility requirements of the directive, the scope of the legislation, so whether it should cover or not public procurement, whether it should cover or not the built environment. In parallel, we were also discussing legislation concerning electronic communications and audiovisual services, which may have an overlap with the European Accessibility Act. So we had to make sure that all these different laws could be complementary to each other. There were discussions, obviously, about the exceptions, disproportionate burden, fundamental alterations, the enforcement mechanism. So all in all, it was a very, very difficult legislative process, very complex, in which the Parliament, the European Parliament, because you need to know that the Commission is the one that proposes the law, but then is the European Parliament, which is the institutions that EU citizens elect directly, and the Council of the EU, which is the one that represents national governments. The Parliament and the Council are the two institutions, the co-legislators, that can amend, and actually did amend, the Commission proposal and need to find an agreement in order to adopt this law. So EDF and with our members, we were trying to influence not only the European Parliament, but also the position of member states. And in the case of member states in the Council of the EU, it was very, very difficult. And actually, some of the shortcomings of the Act were caused or were decided, in our point of view, obviously, by our national governments. But we will get into that.
Thank you, Alejandro. So let's turn to EMA. How did the European Commission partner with the EDF and the US to advance accessibility within the EU? And what is the EAA and why is it being enacted?
Okay, let me start also by introducing myself and thanking you for the invitation and organizing this very timely meeting for the European Accessibility Act, which is becoming soon applicable EU law. So to start with, let me say that I work at the European Commission. I am in the Commission. The Commission is a kind of executive branch of the European Union. And we have the possibility to propose initiatives. We have the power of initiative in the Commission, and I have been working on that from the moment I joined back in '91. The unit has a very wide mandate on disabilities. It's not only about accessibility or digital accessibility, because the unit where I work is the focal point for the UN Convention on the Rights of Persons with Disabilities. The Union is a party to the convention. and has to implement the convention to the extent of its competencies. To do that, we have a European disability strategy that covers all rights of the CRPD. It covers all, we work with all services at the Commission, all different departments, and we work together also with the member states and civil society organizations, in particular DPO, through what we call the disability platform, where all focal points for the CRPD at national level meet together with European level DPOs that we in fact financially support so that they can perform a role in EU policy making. And in the platform, we discuss all the different initiatives within this strategy. We, for example, going beyond the work on accessibility, we have a package for improving labor market outcomes of persons with disabilities. We have a guidance on independent living, how to use EU funds for independent living, a European disability card that makes that persons with disabilities status would be recognized across all the European Union, and many others, some related to accessibility that I will present in a second. So I am a senior expert on disability in that unit, and I am the person responsible from the European Accessibility Act. I started working in the 90s on assistive technology and research on accessibility to move to digital accessibility and inclusion. And I came, I was on the origins of the European Accessibility Act and worked with the different sectors involved, also persons with disabilities, in order to shape the European Accessibility Act. Before we had legislation on the Act, of course, I worked on policies, accessibility policies, and standards. Part of my daily work is to mainstream accessibility and disability in different legislations, European legislations. In the areas of accessibility, for example, in the telecommunications legislation, in the audiovisual media service legislation, we have accessibility in the electronic signatures, even in the new artificial intelligence regulation, there are requirements for accessibility, and on the Web Accessibility Directive, to just mention some. So I will provide you, and now we have the slides on the screen, with a little overview of what the European Accessibility Act is. The next slide, please. The European Accessibility Act basically does two main things. One is to make compulsory a number of accessibility requirements for a selected set of products and services. When they will be placed in the market, they will have to comply with accessibility. The second thing it does is to use exactly the same requirements in the context of public procurement legislation, and with the same requirements also in EU funds. The setting up is a bit different. While for the selected products and services, these accessibility requirements are compulsory. For the others, when the accessibility requirements of the Act are used, it gives presumption of compliance. But there is a general obligation on accessibility, but which requirements to use are up to the different rules. We also have in the Accessibility Act a couple of important elements in scope. One is that those authorities that need to respond to the single European emergency number 112 will have to respond being in an accessible manner. Similarly, of course, the telecom services will have to be accessible, but now we match with the Accessibility Act the supply side and the demand side, and also the products that will have to comply with the same requirements. Basically, real-time text, total conversation would be available for emergency communications. Finally, in the scope, the built environment is a key element, but is optional from the point of view that member states may decide to comply with the requirements at European level or doing it at national level. Once they agree to do it at European level, they have to comply with the requirements of the Act. In the next slide, you can see the products in the scope of the Act. I will read them. It's basically computers, general computer hardwares and their operating systems, self-service terminals, including all payment terminals, and we are talking about terminals dedicated to the provisions of the services in the Act related to ATMs, ticketing machines, check-in machines, and information self-service terminals. Then we have equipment for telecommunications and equipment for audiovisual media services, as well as dedicated e-readers. Then, in relation to services, we have telecom services, with the exception of machine-to-machine services. We have access to audiovisual media service. Let me say that the content of audiovisual media service is regulated in another directive. Here is the access, the websites, for example, that provide access to audiovisual media service. Then certain elements of transport, air, bus, rail, and waterborne passenger transport services, again with a strong digital component, websites, mobile device-based service, electronic tickets, and so forth, self-service terminals. Consumer banking services, e-books under dedicated software, and e-commerce. Any e-commerce provided to the EU will have to be accessible in accordance with the Act. In the next slide, you can see that there are some exceptions or in relation to the scopes. Micro-enterprises related to services are exempted, and there are some mitigating measures for micro-enterprises related to products. There are two safeguards. One, to apply the requirements to the extent that it does not impose a disproportionate burden, and the safeguard on fundamental alteration, that the requirements should be applied to the extent that they do not alter fundamentally the product. But those are some specific details. Now, when it comes to the key provisions for products and services, once the directive is applicable, and that will be in June this year, then only accessible products and services can be placed in the market or delivered in the market, and those products and services get the free movement in the European Union market. They can be placed in any country of the Union. There are specific obligations for all the economic operators, manufacturers, authorized representatives, importers, distributors, and service providers. For products, once they are compliant, they will be marked with a CE marking that will now from June pass to mean that also the European Accessibility Act is complied with by that product. The economic operators will have to self-declare conformity, which is one of the lightest options, but I will say in a minute how that is complemented with other enforcement measures, which is first, market surveillance. Authorities and authorities responsible for compliance of services, those are member states' authorities that will need to check whether the application is correct, to check whether the safeguards are correctly applied, and receive complaints from users, and put also remedial actions, which is at the end what we want to have, that the products and services are compliant. In the next slide, it indicates that we have the possibility to use standards and technical specifications to presume conformity with the directive. We are working on those standards. In addition to the enforcement, the two enforcement measures I mentioned, self-declaration and authorities, national authorities, we have the possibility in the directive to go to court or the responsible administrative body and seek compliance with the directive. Users can do it, disability organizations can do it, and penalties that need to be effective and proportionate but dissuasive can be put by the courts, and of course with remedial actions, because the intention, as I said, is that the products comply. The timeline for implementation is June this year is going to be applicable. Member states are finalizing the transposition, and there is one provision related to emergency communications that will be next in the next 2 years applicable. We will have to produce a report, and the accessibility requirements are in the annex. I'm not going to enter into detail in view of time, but please really look at the requirements in the annex, which contain what is meant by accessibility. In the next slide, you have the reference to the standards that we are, the standardization that we are working on. It's under the heading of Mandate 587, the European Commission. We asked the European standardization organizations to revise 3 standards on ICT accessibility, on design for all, and on the built environment accessibility, to make them conformant to the European Accessibility Act. And finally, to produce 3 new standards: one for non-digital information, how is it to be accessible; one for support services, whether it's help desk, call centers, technical support, to be accessible; and finally, this answering to emergency communications to 112 to be accessible. So that is in a nutshell. I left some references in the last slides to some documentation that you might want to see. I give back the floor to the chair. I hope that this provides with a good overview of what the Act is about. Thank you.
So thank you so much, Ima. As a reminder to the audience, the links that we just showed on the screen will be available in the slideware that will be available after on demand. So our next follow-on question is going to first go to Alejandro. So as we look to the future, what is your opinion of the EAA Act, and what are you doing to support its implementation at the EDF?
Thank you so much. I mean, it is obvious that having the European Accessibility Act, after all those years that I mentioned before, from the disability movement advocating for it, this is a crucial milestone for accessibility in the EU. We were always looking at what other countries, such as the US, was doing, and it has been really a turning point particularly for ICT products and services, as you could see in the scope that Ima just presented. I mean, every time we've run surveys among persons with disabilities on certain products and the accessibility barriers that they encountered. For example, we see in the scope certain products that they have been never accessible for persons with disabilities in most of the European countries, such as payment terminals, for example, ATMs, or even the possibility of calling the European emergency number 112, similar to the 911 in the US. In some countries, they consider, for example, fax the accessible way to contact emergency services, which was totally ridiculous. Or real-time text. We still don't have in Europe real-time text communication across countries. So all of this will be addressed finally with the European Accessibility Act. We also see another positive element. For example, in past years, if you would like to have an accessible TV, you would need to go for the most expensive ones. Maybe now that the market has changed, and obviously we see more and more accessibility features in all the new products in the market, but some years ago, this was definitely not the case. And then we see huge impact on certain sectors like e-commerce and ebooks, for example. If we think of the amount of websites and mobile applications that are considered e-commerce, that they will now need to look at finally digital accessibility standards, this can really have a very positive spillover effect on many other sectors as well. Obviously, from a disability organizations and as disability advocates, we see many shortcomings in the law that, as I mentioned before, were caused by these political negotiations between the European Parliament and the Council of the EU, our national governments that, for example, didn't want Brussels to tell them to include built environment in the legislation. Therefore, we have the situation in which, okay, the bank services need to have their ATMs accessible, but not the bank office, for example. So depending on, obviously, the national legislation in each country. Because let's remember that the European Accessibility Act aims at harmonizing the approach to accessibility, and therefore certain countries may have other provisions covering other products and services, and the Accessibility Act, what it ensures is this harmonization as for the accessibility requirements and ensuring that this set of products and services will have a minimum set of accessibility features. Another key element that we missed, that we believe is a missed opportunity, was household appliances. This is usually the typical product that we always highlight in surveys about accessibility, and persons with disabilities highlight as one of the daily barriers that we encounter. And we believe that with this, the smart household appliances, we could have used some of the accessibility requirements of the Act for the user interface of these new products in the market. Transport services, as you saw in Imma's presentation, the focus is very much on the digital elements of these transport modes, and it does exclude urban and suburban modes of transport, again, because of the national competence in this area, but this is, in our point of view, also a missed opportunity. The enforcement mechanism is very good as for products and services. However, in the original proposal that the Commission prepared, there was a better enforcement mechanism for public procurement, for example. So users can react, and organizations, as Imma explained, can react when they find a product in the market that is not accessible. But if they find that a product that has been publicly procured by a public administration, then there is not an easy way to challenge that decision. And this was addressed in the original proposal, but member states did not accept it. And then we believe that this exception on machine to machine could have been beneficial to have it in the final law, to ensure that this Internet of Things, domotics, and so forth would benefit as well from the legislation. And in terms of what are we doing, well, as you know, we as an umbrella organization, as an organization of organizations, one of our main objectives is to support our members. So we developed, and I encourage everyone to take a look at it, a toolkit for the transposition of the European Accessibility Act. And by transposition, we mean that once this law was adopted back in 2019, the 27 EU member states, they had to introduce national laws in order to be in line with the European directive. So in this, what we call transposition, in these negotiations at national level, obviously, as you can imagine, there are different ways to interpret the law, and therefore we wanted to have our members fully prepared for the negotiations at national level to ensure that they can benefit the fullest from the European Accessibility Act, and they could engage in negotiations at national level, because the directive is quite technical in certain parts and quite complex, and obviously different member states apply different approaches in order to transpose this European law into national laws. We developed webinars, workshops, and so forth. We support our members every time they have a doubt. We have peer exchange meetings regularly. And now we are very much focused on developing those 6 European standards that will assist in implementing the binding accessibility requirements of the law, because the standards are key instruments for industry, for public procurers, for disability organizations as well, to really understand to be sure that they are in line with what the legislation requires. So we are now very much focused on the development of these European standards.
Great. Thank you so much, Alejandro. So our next question is for Ima. What are the top clarifications that you're hearing as you are preparing for this first deadline? And what advice would you give to businesses with the best intentions but need some guidance in this space?
Well, at this moment, we are getting a lot of clarifications on the scope, on the requirements, what are the obligations that economic operators have, as well as how is the directive going to be surveillance by the national authorities and how that can be coordinated. It's important to realize that one of the focus of this directive is the harmonization of accessibility requirements in Europe. So there are clarifications about how is that going to be achieved, that the same interpretation happens across all member states. Also, I get questions, a lot of questions from international stakeholders, because they are realizing they are, for example, economic operators that are familiar with US legislation, Section 508, Section 255 of the Telecom Act, for example, and they ask about what are the similarities, what are the differences in order to comply when they are active in Europe. It is true that when I started working on the European Accessibility Act, I partnered with the US Access Board and the FCC, trying to understand first what the legislation had, what worked, what didn't work, but also trying to on both sides to try to understand how to set requirements that would not put barriers in the market, but that would, being ICT, a global market. So clarifications on that we are setting. Also, and that's a bit more of a concern for me. I'm getting a lot of some questions about how the exceptions work. Is it asking about, is my product exempted? Is my service acceptance? Is it out of scope? And it is really a concern, because I think that the important thing at this moment is to concentrate on the application of the accessibility requirements, because not only accessible products are better for persons with disabilities, but I'm convinced that the products and services which are accessible, they benefit society as consumers in general, because they are more flexible, they allow for easy personalization, and they are more adaptable. So I would even dare to say that when I get questions about the scopes, I try to encourage economic operators whose products and services might not even be in the scope to look into the accessibility requirements and look at the benefits that these accessibility requirements would bring to their products and service. All with all, I see that the clarification questions are getting more mature. Before it was more about what is the act about, when does it apply, and so forth. And now it's really about, you see that economic operators and governments are working on the act, and it's really much more about the details. And as I said, I try to advise them to look into the accessibility requirements and focus on the advantages that the products and service will have, instead of only looking to the let's say the limits of the legislation. Thank you.
Thanks. We too at DQ are seeing that the questions that the organizations are asking are much more specific and much more mature. So another question for you, Ima. What is the European Commission planning as next steps from here?
So currently we are working on a number of things. From a legislative point of view, we are finalizing what we call the transposition phase. This piece of legislation is a legislation that is written at European level, and then member states have to transpose into national legislation. And we are checking that those national laws are complete and correct. And when that is not the case, we then enter into a legal process with the member states, which is called infringements. And currently, well, let me tell you that we take this process very seriously. And at this moment, we have infringements open against all the member states. For some of them, for small details, because I mean, I have to say that they are really working very hard to have conformant national laws, but some of them, they have more work to do. But this is one of our priorities, working on the transposition and on the infringements to have correct national laws. Also, we are working on the standards, on the standardization mandate 587 that we issued a couple of years ago to the European standardization organizations, asking them to develop 3 new standards. I mentioned them before, and to revise 3 existing standards, including the one in the area of ICT. We are working with the standardization organizations also to make sure that those standards would be ready as quick as possible. The priority is really to, at the end, to receive those standards that should be complete and correct, because the Commission needs to check. I need to check where those standards are okay. And then if that is the case, we need to publish a reference to those standards in the official journal of the European Union. Only then those standards, applicability, the application of those standards, the conformance with those standards will give presumption of conformity with the accessibility requirements of the directive. Finally, another, 2 more points. One is that we are looking into the matters of e-books, because the standardization mandate 587 did not address e-books at the request of the publishers and users, because there was an international standard and the directive allows it. That could be applicable. So we are looking into that standard and consider the making of technical specifications referring to these international standards. Finally, we are looking into some other formal commitments in the directive, like setting up a committee that is necessary, a committee with representatives of member states to approve such technical specifications, and a working group in which we are going to put together the market surveillance authorities, which are those that check products, and the authorities responsible for compliance of service, together with representative organizations of users, persons with disabilities, and other stakeholders. The idea is working together to have a common understanding and support the coherent application of and correct application of the directive across all the countries of the European Union. So those are our priorities. And I understand that there is will be a session on EN 301-549, the standard on ICT accessibility, also at another moment.
Great. All that stuff is well needed, and we're looking forward for those clarifications and fine tuning with the member states. And thank you so much, Alejandro and Ima, for all this amazing information about the EAA. We're going to turn now to Ryan, who's going to help us lead us through our audience participation questions.
Fantastic. Thank you so much. Yeah, just a reminder for all of y'all, head to the questions section, upvote the questions that you think are most important that need to be asked, especially questions that were asked later. I know that I'm seeing a lot of questions in here that were probably eventually addressed by the presentation itself. So please get your questions submitted and upvote what you would like me to bring to the audience or to our panelists here. Let's see, the most popular question at the moment is, let's see, for those of us who have been obligated to comply with WCAG or WCAG and will now also be subject to EAA, is there anything new we must address?
Okay. You want me to answer already?
Please, yeah. If you'd like to, Ima, yeah, take it away.
Okay. So just to reassure all of you that we are taking good care that the standards that are applicable for the EAA. So in relation to the web, that is for the time being the one that is being reworked to be useful in that area is EN 301-549, contains a section on web accessibility that is aligned to WCAG. What might be new is that depends on which version of WCAG it will be considered, but also there could be some additional requirements in relation to supporting persons or addressing the accessibility of persons with cognitive disabilities. But for the rest, I mean, it's really well aligned with WCAG. In fact, it points out to WCAG.
Fantastic. I'll move on to the next question. Alejandro, Matthew, please interrupt me if you at any point want to also jump in with an answer. Okay, next most popular question. What can the UK expect on this since leaving the EU?
Do you want me to take it?
I mean, yes, you can start and then I can complement if needed. Thank you.
The Brexit question. The UK did transpose the Web Accessibility Directive, so the one that I mentioned at the beginning concerning the public sector websites and mobile applications. As far as I know, the UK has not introduced any national law that could be in line with the scope and with the accessibility requirements of the EAA, the European Accessibility Act. However, we do believe that it will have a kind of like a collateral positive effect in the UK, because at the end of the day, we are talking about products which are sold at a global scale in many cases, and standards such as WCAG that are the international acknowledged standard for digital accessibility. So all in all, we believe that the positive effect that the EAA will have in the single European internal market will also benefit, obviously, the UK market as well, because the same products that will need to comply with the EAA, these companies will sell them as well in the UK with the same accessibility requirements. There may be certain provisions, obviously, in which UK consumers with disabilities may not be as protected as EU citizens as for the enforcement of these accessibility provisions, and certain elements which do not fall into the product itself, such as, for example, the support services that Emma was referring to as well. We believe that it can have a positive effect, but obviously not all of it will come as far as I know, but Emma, feel free to complement.
Yes, thanks, Alejandro. I think you gave a comprehensive answer. Just to add one point, and that is that the European Accessibility Act contains provisions for importers of products. And this means that if products are manufactured in the UK or outside Europe, it doesn't matter where, and they would enter the European market, they will have to comply with EU legislation. So similarly, services that are provided from UK or from other parts of the world in the EU market, so when those services are delivered in the EU market, will have to comply with the European Accessibility Act. And let me be clear, because it's one of the questions that I get very often. There is some European legislation that uses the principle of the country of origin, meaning that, okay, you only have to comply with the requirements of the country where the service is developed and launched from. In this case, there is nothing in the European Accessibility Act referring to that principle. On the contrary, it says that all services delivered in the European Accessibility Act will have to comply with the accessibility requirements of the Act, wherever they are originated. The moment that they target the European Union market, they will have to be compliant. And this applies for any country on the in the world where services might be originated, whether it's e-commerce, for example, which e-books, then they will have to be accessible in accordance with the Act. So I think that will also affect the UK market. Thank you.
Thank you so much. I think we've got time probably for one more question here. This is a perfect segue, Ima, in what you were just talking about. This question is asking if a US business that does business in the EU is actively remediating web accessibility issues, but does not completely resolve all of the issues before the June deadline, will that business face penalties or fines in the EU?
They might.
It depends.
It depends.
Right?
It depends. I mean, it's clear that those companies from the US or wherever they are coming from, the moment that they place products in the market, they will have to be compliant. If not, then they will risk that there are complaints from users, that the market surveillance authorities would knock on the door and say your products are not compliant, and someone might take them to court. In fact, the market surveillance authorities for products might decide to ask to withdraw the products from the market. So this is a possibility set in the directive. So in addition to remedial actions being required, in addition to this withdrawal, there is the possibility of facing penalties. Similarly, for service providers, if they are not compliant, they might be withdrawn from the market and follow also complaints, remedial actions, and penalties. Yes.
Fantastic. Thanks so much. There are a number of people asking Alejandro for the toolkit that you mentioned, in particular the link. I don't know if it's something that you have available or if the URL is entirely too long to read aloud, but if you've got that, the audience would love it. If you don't have it available, I can get it and send it to the chat group following.
I can find it for you and paste it in the chat if that's okay.
Yeah, fantastic. And any parting words from the group here as we wrap up? I really appreciate your time. Everyone, thank you in chat and Q&A. The audience, fantastically engaged. Thank you, Alejandro. I'll get this link to everybody. Any parting words as we wrap up here?
Are you asking each of us to give a couple of words, or?
Yeah, absolutely.
Okay, so I mean, for me is that the message I would like to leave is that the 28th of June is going to be a very important date. Please don't wait to take action to the 28th of June. Be prepared and make sure that your products and services are accessible when placed in the EU market. The other message I would like to say is that we are finalizing all those standards at European level, and I would like to invite all of you to participate. Particularly in the standard on ICT, there is the possibility to participate online, because the intention is that those standards serve the purpose for all the sectors of the directive. So if you are from one of those sectors, please participate and make sure that your contributions are there to have a standard that is suitable for its purpose. Those are the main
Thank you. Thank you so much.
final words from my side.
Really appreciate that. We're at time here. Thank you so much. Fantastic session. Have a fantastic rest of your day, everybody, for day 2 of AXCON here.